Okay, Lena, take it away.
All right. Well, welcome everyone to the Florida Agritourism Association's final webinar of 2023. We really appreciate you joining us. We know this is a really popular topic for all of our members, and we have a longtime friend and advocate of tourism, Timothy Riley, who has been our legal counsel and all-around supporter of our work for many years now. I know that Sarah flashed his bio earlier today, but I'll give you the short version. Timothy is now with Gunster Law Firm in Tallahassee, and they have offices all throughout the state of Florida. 13 years of experience with government affairs, land use law, administrative law, environmental law, and he is an adjunct professor teaching oil and gas law and military justice at Florida State University's College of Law. I would love to be a student in your class. That'd be fascinating, Timothy. Timothy is also a veteran who served in Afghanistan and in support of the Operation Enduring Freedom with the 82nd Division, Airborne Division. And I just want to thank you so much for all of the support you've offered us through the years. And I'm going to let you take it away.
Thanks, Lena and Sarah. Hello, everybody. Let me get the presentation up. Let me make sure I can do this first.
Perfect.
From the beginning, actually start it. Okay. Does it have the presentation up?
Yes.
Awesome. Well, hey, thanks everybody, and thanks to the association. Lena, I was going to go back and look at my notes. The very first presentation I did was in January of this year, so I think I'm bookending your webinars. So I think the first one in 2023, I did the last one in 2023, and I always appreciate the opportunity to come talk to y'all and the members, and appreciate all the hard work that the association has done, and the work that Lena and Sarah and the team has done on behalf of agritourism operators. So today, I want to talk about understanding the liability shield law. I spent a lot of my time in my practice talking about issues about preemption with local governments and land development regulations and whether they apply or don't, or dealing with property tax assessors, the property appraisers on greenbelt classification and keeping it or losing it because of agritourism. But what often gets missed in these conversations is probably one of the main reasons that one of the main reasons that the agritourism law was put in the first place was to create a liability shield protection for farmers and ranchers, to give some protection for when unfortunate accidents occur on the properties when you invite the public onto farms and ranches. And so today, I spent the first one in January talking about greenbelt and preemption of local government. So I thought I'd bookend it on the back half by talking about the liability shield directly. So that's what we want to do. So I'll give a kind of a breakdown of the statute that talks about the protection, talk about what we mean by inherent risk of agritourism activity, what that is and what that isn't, talk about when that liability shield probably is not in your best interest, and then talk about some general best practices and open it up for questions. Again, I'll just show this picture because it's a better haircut than the previous one. And I appreciate Lena talking a little bit about my practice, but just in general, I'm a government law attorney and litigator, and I primarily represent agribusinesses, mining companies, exploration companies, and commercial developers working to develop their issues deal with their issues with government. I represent a number of agritourism operators, and it just goes from my longstanding relationship with the agritourism industry over the years, and I help them primarily with their land use issues and again with greenbelt issues. I'm just going to stay right up there. I am not a personal injury attorney. I'm not a slip and fall attorney, and I'm here going to be talking about slip and falls for the next 30 minutes. But I'm familiar enough with this particular statute and how it applies and some of the left and right limits about it that I feel comfortable talking to you about it today. Just a big disclaimer, this is general information. Please, if you have any particular concern, do not act based on solely what you're hearing from me. Please talk to an attorney. The reality of what we're going to talk about today, you're going to want to talk to 3 different people. You're going to be wanting to talk to your attorney, you're going to want to talk to your accountant, and you're going to probably want to talk to your insurance broker. Please make sure you talk to an attorney. Don't just take what I say today and just run with it. So why are we talking about this? So I think assuming everybody on this call is an agritourism operator, means you're a farmer and rancher. First and foremost, we have these beautiful bucolic properties all throughout Florida. We want to invite the public to come and see and experience what we do. That's part of the exciting aspects of agritourism. We want to bring people onto the property to see to educate them about farming and ranching operations. We want to use those lands as a vista for doing civic ceremonies like weddings and events, and just bring the people out from the city and from the suburbs out into the country and experience that lifestyle that many people wouldn't otherwise get to do. And on top of it, we want to monetize that. We want to generate revenue from it so we can keep being farmers and ranchers. The flip side of that coin is that the farmers and ranches also come with a lot of what we call inherent dangers in the statutes. We've got gators and water moccasins and rusty old equipment that's super sharp and uneven roads and buildings that are not built or designed to be built to building codes, and wasp nests and animals that kick and bite. And my personal favorite, lots and lots of poison ivy. And that's a risk that comes. And we're going to be inviting the public. Many of the people that you're inviting don't have experience in these types of environments, and and it's not necessarily out of the realm of possibility. If you bring some city folk out into a blueberry you pick, that they're going to come back with a beautiful bouquet of poison oak, right? And that's going to be a bad agritourism experience for them on that day. And then in the following day, there's probably a good chance that you may get sued. Right. And that's why 57088 was created. Right. It was meant to create a liability shield for farmers and ranchers who are otherwise doing good and normal customary farming and ranching work, recognizing that there are inherent risks associated with being on a farm and ranch. And that's saying that if you're invited, so long as you do certain things and you invite the public to participate in agritourism activities on your farm and ranch, the inherent dangers of that farm and ranch won't be used against you in a lawsuit if someone gets hurt or injured or God forbid dies on your property. And so here's the statutes in section 57088 of the Florida statutes. It's the section's pretty straightforward. It's a pretty easy read, but it's deceptively simple. There's a lot of things going on to it. And what I want to do today is kind of start unpacking some of those things, just so you have that in your head as you go forward. The first thing is, who's protected? So who's the good guy and who's the bad guy? So first off, in terms of the good guys on this statute are going to be your agritourism operator, their employees, and the owner of the underlying land of the agritourism operation. Now, generally, in a lot of cases with your small businesses, small agritourism operator, it matter, you're the only employee and you own the property. You may have more sophisticated operations, where you do have employees, where there's a distinction between the landowner and the property owner. And that seems pretty straightforward, but you got to start thinking about what it doesn't include. It's not going to include contractors and vendors and family members, for instance. So if you're an agritourism, if your operation includes bringing vendors onto the property who provide a service in relation to your agritourism operator, are they a protected class under the statute? Probably not. Family members, if you've got your 14-year-old son driving the tractor that's pulling the hayride, and they're not an employee of your operation, is that person? Well, they're a minor, so they might have some protections there, but are they technically covered under this protected class of people? And the answer is probably not. Or if you have volunteers or neighbors that are coming out and helping, are they protected? Maybe not. So it's important to understand that, when most think of agritourism operator, we think of people who, are doing it, but you just got to think that in terms of the statute, it's kind of a narrow bandwidth. There's only 3 classes of people that are going to get that protection. Anybody else doesn't have this. Now, it doesn't mean they don't have other things that would protect them, but when it comes to 57088, it doesn't. And then it goes to, well, who's the bad guy? It's going to be a participant, right? So this shield's only going to protect you if a participant is hurt, injured, or killed on the property. So if you have other people on your property who are not participants in your agritourism activity and they're injured, then 57088 is not going to be applying in that particular circumstance, right? So if you have a farm and your primary income is agritourism, but you have a plumber who's coming on to do some work and they get hurt and they sue you, right? 57088 is not going to protect you in that circumstance. If you're inviting, you're an agritourism operator in your farm and you're inviting the neighbors to come over to hang out and they get bit by a water moccasin and they sue you, 57088 is not going to protect you, right? Because they're not a participant in your agritourism operation. And it's important to understand that none of these terms are defined within 570 except for an agritourism operator, and it's defined as a person who's engaged in the business of providing one or more agritourism activities, whether for compensation or not. The key word is in the business, right? So you have to be in the business of providing an agritourism activity, whether you're getting paid or not getting paid. You have to have a business enterprise in order to have that status. So if you're a farmer or rancher and you just simply, you're not intending to be an agritourism operator or do not have a business to provide an agritourism, but have somebody come onto the invitee onto your property, like for instance, you're a farmer and you're ranch and you have a blueberry patch that just happens to grow wild, and you said, hey neighbor, you can come on, go pick all the blueberries you want, and then they end up getting bit by your horse or something like that and sue you. 57088 probably doesn't apply to you in that circumstance. Why? Because you haven't set yourself out in the business of being an agritourism operator. So that's an important thing to keep in mind. Some people are pretty informal about their agritourism operations. Some are more formal. More formality is probably better than none. Talking a little bit about inherent risk of agritourism, right? So what is it about? It's going to protect you from if someone is injured, dies, or suffers damage or a loss for participating in an agritourism activity as a result of the inherent risk of that activity, if notice of the risk required under Section 57089 has been posted and required. So there's a lot going on there. But the very first threshold thing before you can even claim, the defense is you've got to make sure that you've met the notice of risk requirements under 57089. 57089, again, very simple, but also it's got a lot of bells and whistles in it, right? And if you're an agritourism operator, then I imagine probably everyone on this call has the signs that the associate has prepared and you posted them. But that is a requirement. No signs, no protection. And there's specific requirements to those signs. You have to have one that's clearly visible at the location at the entrance of the entrance, and you also have to have one at the site of the agritourism activity. So I tell clients, even if those things are right beside each other, you should probably have two signs, right? There are very specific requirements. They have to be black letters. Each letter has to be a minimum of 1 inch in height and have a sufficient color contrast to be clearly visible. These are, again, I'm not involved in personal injury litigation. I do know it happens. I've been engaged in some of them as on the agritourism side of it issue, as opposed to just litigating them. And I can tell you whether it was an inch or whether it was 3/4 of an inch can matter in terms of litigation as to whether this shield is going to apply. And so, and again, you think it's pretty clear instruction, but maybe not. Clearly visible location at the entrance to the agritourism location and at the site of the agritourism activity. So if you have a bunch of different activities, do you need to have a sign at each one of those activities? I tell clients, yes, right? That's probably better than not, particularly if it's spread out over a large farm or ranch. And if you've got the corn maze is 1,000 feet away from where the U-pick is, then you probably need to have a sign in each one of those locations. What people often forget is that there's also a requirement with each written contract entered into with with a participant that you're providing professional services, instruction, or rental equipment needs to also have the language, right? And so if you have a contract, right, which you have some type of agreement or you have some type of paperwork that's between you and the participants that are coming on that property, you need to have that warning language in there somewhere, right? And I usually boldface it, all cap it, or something like that, So it's really clear in there. So again, if you have a circumstance where you have a posted sign, but it's not in your contract or with the services that you're providing, right? Could there be an argument that there's a gap that privilege doesn't apply? Possibly, right? So it's important to make sure that, particularly if you're doing wedding barns or anything like this, in terms of your agreements with the guest and whatnot, that those contracts all have that language in there. And then it's very important at the very bottom, failure to comply with this section will prevent you from having that shield. So if there's any failure, whether it's substantive or technical, doesn't matter how small or small it is, you will lose your liability shield, right? You must meet both posting and contract notifications. And I hear questions about deviations all the time. Well, can I put my signs in Spanish and will that count? Definitely put your signs in Spanish, right? And the more coverage you have. But if you only have a Spanish sign, but it's not English, you may not have coverage, right? So you're going to want to have dual language signs. Posting in additional locations. Can I post more signs and I can post some other locations? Absolutely. But if you have additional signs, but those signs are not at the site or at the entrance, probably are not going to give you protection, right? So follow what's in there. If you want to go above and beyond, absolutely. It probably gives you, it makes it even better when you get into into court. So next we want to talk about inherent risk of agritourism. And there's a definition in 570-86 for what's an inherent risk of an agritourism activity. And it means those dangers and conditions that are integral part of an agritourism activity that include certain hazards such as surface and subsurface conditions, natural conditions of land, vegetation, waters, and behavior of wildlife and animals. And then it's got this second that's really great. The term also includes the potential participant to act in a negligent manner that may contribute to the injury of the participant or others, including failure to follow instructions given by the operator or failing to exercise reasonable caution. This is a great definition. It's got a lot in there. It gives you a lot of coverage. However, there are some left and right limits, and it's important to kind of understand them. So let's take an example. Let's take kind of a slip and fall where we have what you're going to routinely see. Let's say you've got your wedding barn and you've got a dance floor and you over-wax it and it's super slippery and somebody falls and hits their head, versus you allow people to do interpretive walks across the farm and it's a muddy, wet day and they slip and fall. Is there a distinction between those two? There very well could be, right? Because the inherent risk of agritourism is part of the agritourism activity, right? So a farm, in terms of definition, we're talking about ordinary dangers of structures, equipment, and ordinary use of the farm and whatnot. So if you've got a dance floor that you over-wax, is that an inherent risk of being on a farm or ranch? Arguably not, right? Now, I think there's a good argument to say, yeah, because, it's part of a wedding barn, that's the agritourism activity, but there certainly could be a very good argument that that's not the intent of the farm, right? It's to protect people from, reasonably known hazards that are common and ubiquitous with farms and ranches, and an overly waxed dance floor, not necessarily it. Versus if you're out on a muddy, horse or cow trail after a rain, that would be something you would normally see. Participants' negligent conduct, right? I'm from Texas, and at the time I grew up in a county that had more horses than people, and I've learned the hard way, like maybe many of you, that if you taunt a horse, bad things happen, right? And people will do that. People want to poke the horse. They want to pet the porcupine. I like this scenario. If any one of my clients ever showed me a picture of this and, hey, do you think this is okay? I'd probably say, you know what, we're going to up my retainer a little bit here. But what if you had a scenario where instead of following the instructions of the operator that said, keep your kids in their lap, they let the kids sit at the edge of here and they hit a bump going up this hill and they fell underneath that trail, right? These are all things where you can potentially argue, you know what, participant, you acted in a negligent manner, you didn't follow instructions, and you're not using common reasonable sense interacting with our space, and therefore your injury is really more your fault than mine, and therefore I'm going to have protection from the liability shield. An important aspect of what's within the scope of it is there's a clause in here that says, as such, and it lists out the different types of activity, materials, surface and subsurface conditions, conditions of the land, vegetation, water, behavior of wildlife, animals, and ordinary dangers of structures, equipment ordinarily used in farms and ranching. Such as is really important. What does that mean? It means specified kind or a list of examples. It doesn't say such as, including but not limited to. It says this. So really, as a matter of law, what is going to be an inherent risk of an agritourism activity is going to be generally described, is it an activity that or a risk that's inherent with these types of things: the land, the vegetation, wildlife, and ordinary dangers of structures and equipment, right? It's not going to be anything else. And let's take an example for it, right? Let's talk about structure. Let's say you're going to have, one of these blow up bounce houses at at an agritourism event, and you've got this, maze here, hay bale maze, right? These guys slip and fall off this versus somebody slipping and falling, get hurt on this, right? Pretty good argument to say that, these hay bales, are a normal customary thing. You've given some type of instruction, right? This is something that would be customary on a farm. You probably fall within that definition. Whereas this structure, this is a little more iffy. I can't guarantee that a judge won't say, you know what, this doesn't fall within any of these. It's not dealing with the land, it's not dealing with wildlife, it's not dealing with vegetation, and it's not an ordinary danger and whatnot. So therefore, if you bring this out, even though you've got the signs and even though you have everything else, right, there may be an argument made by a participant who's injured that the shield doesn't apply to you. You probably have a better argument in this type of situation if someone's hurt, say slips on the mud or something like this running through here. Things to keep in mind. Another example, you bring out, you buy and set up a bunch of benches. For your agritourism operation, just so people have a place to sit while they're doing whatever events you're doing. So take the instance of someone falling off something, right? So if somebody falls off a horse as part of an agritourism event versus somebody falling off a bench that you brought in, is there a distinction, right? A plaintiff's attorney is going to try to make a big distinction about this, right? So one, probably have a pretty good argument, right? If you're doing something where someone's allowed to be on a horse, again, there's probably lots of risk analysis you want to be doing with that to begin with. But if someone's on a horse and they get bucked off a horse, right, you probably have some argument to be made that that's within the scope of what's intended in that list, right? Because you're talking about the normal behavior of animals, horses buck sometimes to, do it. Versus this, if this bench otherwise wouldn't be on your property because the only reason it's there is because a part of your agritourism operation and you build it either correctly or incorrectly and somebody falls off that, could they make an argument that that doesn't fall within that list of land conditions or ordinary structures or dangers and whatnot? Certainly possible, right? So in this case, right, you're doing something nice, adding an amenity to your surface, your agritourism operation could lead to a chink in the armor in terms of your liability shield, right? Now, can't say that definitively one way or another. There is absolutely no black letter case law when it comes to 57088, which means there's no written appellate court decision to discussing these terms, applying it to a particular fact pattern. I know there's been litigation in some jurisdictions, the circuit court, but there's nothing in terms of appellate black letter or case, judge-made law that gives us any guidance on this, right? So it's a little bit of a Wild West scenario that you have to deal with. Again, I'm just bringing this up as a potential distinction. Now we start talking about when does this, when can these immunities attach and when do they not attach? And so we move to the second part, is except as provided in subsection 2, which we'll talk about in a bit. A participant may not maintain an action against or recover from an agritourism operator for death, damages, or injuries or loss if it results exclusively from any of the inherent risks of the agritourism activity. So a number of important things going on. First off is may not maintain an action, right? So the first thing is this could be a bar to proceed with the litigation. So you get sued, right? The first thing you're going to want to try to do is get it dismissed. You're going to dismiss it because you're going to say the immunity shield is intact as a matter of law based on the 4 corners of the complaint. It clearly their injury is slowly as a result of this, the inherent risk of an agritourism activity as pled, therefore we want it dismissed, right? So it gives you grounds for dismissal. Now, the other thing is it has to be resulting exclusively from any of the inherent risk of an agritourism activity. So if you've got a slip and fall incident and you're getting sued and it's because of, and they want to plead that it's not just because of the inherent risk of the agritourism activity, right? That case may continue, right? You may still be exposed to liability because of an argument about whether the agritourism activity, the inherent risk, was the exclusive cause of that injury, right? And exclusive means, and again, we look to the definitions of the term because these are not defined in this particular statute, and it's in a way limited to a single person, group, activity, or method. So it has to be the single, it has to be the sole essentially cause of the risk. Now, I say this because plaintiffs' attorneys are going to be very aggressive about this. They're obviously going to say, they're going to try to find every opportunity to stay in the case, right? And they're going to say there's a whole lots of things that were going on that resulted in that injury because they want to keep that case alive. Next, we want to talk about when is this immunity not going to apply? And it comes down to this second paragraph, right? And so there are things that you could do as the agritourism operator that, your actions or omissions that may cause you to lose your own liability shield. And that's going to be if you do something that's grossly negligent or willful or wanted disregard for safety, or you intentionally injure the participant, right? In those two scenarios, you're not going to have the protection of the liability shield. All right. So those are the two areas. So let's talk about each of them. So we're going to take intentionally injured participant first, right? If you beat up the participants that come to your property, right, you're not going to get any protection, right? You can't intentionally inflict harm on the people that come onto your property. That's just not going to, you're not going to get the protection. That's a pretty straightforward one. Gross negligence, on the other hand, is a little bit more complicated. And this is from the Florida jurisprudence. And it gives you a general summary of what the law is in Florida as to gross negligence. And that's going to be acts with a conscious indifference to the consequences to other persons, and the course of conduct that a reasonably prudent person would know is likely to result in injury to another, right? The elements of it are circumstances constitute an imminent or clear and present danger amounting to more than normal unusual peril, knowledge or awareness of the imminent danger on the part of the tortfeasor, which would be the operator, an act or omission that evinces a conscious disregard for the consequences is distinguished from careless disregard thereof or more extreme willful or wanton disregard conduct. Basically, it's if you know about a clear and present danger, you don't do anything about it, and someone gets hurt, that's gross negligence. Wanton negligence is that you have absolutely no care or absence of any care of the consequences of your action. So wanton negligence is, basically I don't care absolutely at all. I'm not taking any precautions. I'm not going to give everybody notice. I know there's something incredibly dangerous, and I don't care if anybody finds it, falls into it, gets bit by it. Gross negligence, not as bad as wanton negligence, but essentially is saying that that there's a clear and present danger and you do nothing about it. The good news is if you're simply negligent, which is just not following the duty or standard of care that you would otherwise, that a reasoned person would have, that's not in there, right? You could be negligent and still potentially have that shield apply. What it says is that you automatically won't get that shield if it's gross negligence. And what are we talking about? So if you have this beautiful barn right here, and you go, you know what, this is the most bucolic barn in all of Florida. I'm going to turn it into a wedding venue, right? And it's infested with black widows and it has a bunch of exposed rusty nails, right? And you know this, and you don't do anything about it, and you still bring 100. You cram this thing whole with 200 people, right? And people get bit by spiders, and they have to go get tetanus shots because they're all getting chewed up by these nails, right? That's probably gross negligence, right? That's going to be a bad day for you. You're probably not going to get coverage, right? So what does that mean? It means that you have, even though a lot of some farmers ranchers that says it is what it is. People come out there, they know. I tell them don't do it. But the reality is you have to have a fair amount of due diligence with your property. You have to know what those risks are. And if there are notoriously an open risk to it, you need to essentially mitigate that. You need to mitigate it by removing that risk, isolating that risk from where you're doing your agritourism activity, or certainly putting people on notice, right? Black widows are in Florida. There are rusty nails in old barns, right? You guys listen, we've done everything we can to deal with the rusty nails and black widows. We can't guarantee everyone is out there, particularly if you've got children that are part of your participants into it. But having instructions, putting them on notice, having safety briefs, having material that says, hey, listen, you need to be vigilant about these types of things when you're on our property. Welcome to rural Florida. These are, these are our neighbors and friends too, and you need to be able to co-live with them just like we do. So that's kind of the statute. I want to talk a little bit about best practices, and I'm going to talk about it in 3 different silos. The first one is talking about your business entity. So the first thing I always tell clients when they talk to me about the liability shield is, as I always say, pretend it doesn't exist. Do not exclusively rely upon the protections of 57088, because if anything in this presentation has shown you is that a plaintiff's attorney can find a number of different ways to attack, bypass, mitigate, push through that liability shield and get you in court. And it doesn't stop you from getting in court in the first place. It doesn't stop you from expending, a substantial amount of money and time with attorneys to get to the point to dismiss a case, assuming you're able to do it. So what I'd say is you don't want to rely on it. We'll talk about insurance and some other things in the first, but one of the things you want to make sure you do is you're setting up your operation in such ways that you're minimizing your personal exposure and minimizing your personal wealth and your family's wealth. And so I always talk about, when you're setting up, you want to become an agritourism operator. What I want to do is talk like, okay, how are we setting up that operation? How are we setting up that business? How do you own the property? How is the farm run? What is that business? How are you going to, if you're going to have vendors and contracts and other services that are provided, how are we having those relationships? How are we contracting it? How are we creating those businesses? How are we running those businesses? Are we running those businesses in such a way that they can actually provide, if you're setting up your LLCs, are you setting it up and actually running it and using it in such a way that you can actually get the benefit of the limited liability of your limited liability company, right? And so that's an important concept. And that's beyond the scope of this conversation, this talk about all the things that go into it. And it's usually, and more often than not, it's unique to each individual business enterprise. But that's something you want to take very seriously, is about setting up your businesses, setting them up so they interact with each other ways, so they are independent businesses, and that you're setting up your contracts and your leases and your agreements and everything like this, that they are designed to protect you. So when someone does sue and they sue your agritourism operation, right, your underlying farm business or your family business or your own personal wealth are not at stake in that slip and fall personal injury lawsuit. Operationally, what are we doing about our farms and ranches and our properties itself to mitigate or avoid those risks? Are we repairing, removing, or isolating known hazards? Are we doing our due diligence to identify hazards that are not known to you? Are we providing safety briefs and materials to the participants? Are we routinely patrolling our property? Are we avoiding, we avoid particularly dangerous activities? There's a lot of activities out there that, you know what, I may be able to make some money on it, but if you do a cost benefit analysis of what's the likelihood of somebody getting hurt versus the revenue you're going to generate, you're going to do it. Alcohol is always a big thing, particularly with the wedding barn, right? You're going to allow alcohol or not allow alcohol in the presence, right? The presence of alcohol changes the dynamic, increases the risk factor. And are we having qualified and trained staff operate our agritourism operation? If you're a small operation, it may just be you and your family doing it, right? You have to really step back and go, I may be the best farmer and rancher in the world, but am I really good at whatever this agritourism? I have a good idea for an agritourism, but am I actually really the one best qualified to do that? If you have a more sophisticated operation, right, where you're actually hiring staff, I know a lot of times there's a number of larger operations where they're hiring, during the summers, they're hiring high school kids as part-time employees or something like that. You got to really step back and go, listen, they're within the umbrella of my company and their actions or inactions could expose me to liability. Are they really qualified and trained? Have I made sure that they have the skills necessary in order to properly employ those agritourism activities to avoid risk to you? Finally, talk about insurance. nobody, there's not a single client. And if there are any of my clients on this call, they can back me up. I'll never ever say, just get that. Just, you got the shield, you're good to go. I always recommend that you get insurance coverage, whether you're getting general liability, commercial, farm, or whatnot. This is something where you want to talk to your agent. You want to talk to your CPA, and you want to turn it back because you want to make sure you have the right insurance coverage for the different types of businesses. And it's important to remember, particularly with agritourism, there's a lot of insurance companies that don't really understand what we're doing. And so you have to be very careful about the terms and the exclusions of these insurance policies, right? And go, are they really covering you for the types of activities you're doing? Or did you just buy an insurance policy that pretty much everything you're doing falls into one of the exclusions and it becomes worthless, right? It's very important to sit down and actually work with your broker and with an attorney and go through those coverages and exclusions and go, does it actually work for me? And it's important to understand too, that when we deal with vendors and contractors, if you bring food trucks in, or if you're providing bartenders, or if they're, you got the bounce house guy or whatever it is that you're doing it, or if you're bringing someone else's tractor on or something like this, that you've got, make sure that everybody you're dealing with that's providing a service or you're doing a service has their own insurance, and that they separately name you and your affiliated entities. So you have co-named coverage, right? And that's part of your requirements. And then are you ensuring that the right policies will cover you at the right time? Particularly if you have farm insurance, if you have, and then you're getting an event insurance, and you're getting a general liability policy, a bunch of different policies. If something happens, the first thing they're going to want to know is, what insurance do you anticipate is going to be the primary insurance that's covering you, and which ones are the backups? And did that insurer agree that they're the primary and not the backup? Because if you've got 3 different insurance companies with 3 different policies that may particularly cover the incident, a reported claim, what can you expect? No insurance company wants to pay out, right? So if you've got multiple policies, right, the first thing those insurance carriers want to know is, do you have other policies? Could somebody else cover this particular claim, right? And so you could end up in a situation where your insurance companies are just simply fighting amongst themselves instead of not protecting your interests, right? So it's important to remember, as you get multiple policies, that you're working with the insurers and the brokers to figure, okay, in these types of circumstances, who's primary, who's secondary? Do you agree or disagree with that? So you know ahead of time, they know ahead of time as you come into it. Waivers. I always encourage this too. If there's an invitee on your property, right? What are they, what can you do to have them physically sign something that's a big waiver in big bold letters that says, I invitee, I know I'm coming onto a farm and ranch. I know that there are inherent dangers to the ranch. I understand that there are going to be these activities on this ranch, and I understand that I want to do them, and I choose to accept the risk. And if I get hurt, it's on me, and I will not, and it cannot, and will never sue you, right? Get waivers. Wedding venues are a tough challenge. A lot of time, there's a lot of contracts and everything that go in with the wedding party, right? You have a contract with them, and you have an event insurance, and they have to carry policies, and they're the ones responsible for covering the insurance policies on the bartender and all this kind of stuff like this. But what about the 200 guests that are coming with them? Right? They didn't sign anything. A lot of times people ask, should I get everybody who walks through the door sign something? And I tell them, like, listen, right there at the book where they sign the wedding registry, there should be forms where they're signing the liability waiver, right? Some of my clients say, that's a little, that just kind of ruins the vibe, and I'm not doing it. And other ones are like, absolutely, and what I tell them is, at the end of the day, if Uncle Johnny, gets a little too tipsy on the floor and gets hurt and sues you guys, it's going to be hard to say, well, the bride and groom signed a waiver. Well, where was his waiver, right? So it's just something to think about. I always encourage getting waivers. Whether you're getting them online and you have to fill out the forms online ahead of time and then you get proof of it, or whether you're doing it at the door or physically signing it, that's typically better. I always encourage getting waivers. Vendor contractor waivers, indemnification, right? So you're going to bring a bunch of vendors and folks on, service providers on your company, right? I would try to do is, when you get a contract for that service, is you get them to indemnify you, right? If they do something that causes somebody to get hurt, right? You as the underlying property owner, agritourism operator, is probably still going to get sued, even though it's their fault. Now you're having to sue them, say your fault, right? I'd like it to get indemnification. It says, you want to make money on my agritourism event contract, what you're going to do is you're going to sign a waiver. You're going to indemnify me. You're going to agree to do that. So if you do something that gets somebody hurt and they sue me, you're defending it. It's on you. I always encourage that. and effective documentation, just making sure that your contracts and your leases and your agreements, whether it's with the participants or it's whether your third-party vendors, is clearly documented, is clearly protecting your best interest, indemnifying you against those risks and mitigating those risks. So that's the presentation. I threw a lot at you, but it's an important topic. There's a lot of different things you can go into it. Wanted to be able to save a few minutes for questions, but really appreciate your time listening to this. And it's not the most exciting topic in the world, but hopefully made it interesting and informative. Thank you, guys.
That's very, very important information. Thank you so much, Timothy. So I did have a question early on. If your employee is one they have 1099, so they're a contract employee, does that count as an employee early on?
That's a good question. That's not defined within the scope of the statute. I'd probably want to turn to one of my personnel law specialists. So you know what? I'm just not going to risk it. I don't know the answer to that question. I don't want to shoot from them.
And the other question was about waivers and contracts, which you just addressed. And so for bounce houses and the picnic table example, you also mentioned getting insurance.
Yeah, absolutely. I mean, and I know there's a lot of people that have those types of, there's a lot of people that you bring amenities onto the property as part of the agritourism activity, but you got to think, in terms of that inherent risk, are those types of things that you're bringing onto a farm the inherent risk of the farm? Probably not, right? So the best answer for that is just insure your way around it, and then waive your way around it, insure your way around it.
Okay, did anyone else have any general questions for Timothy?
Timothy, I really appreciated your very colorful examples of risks inherent on a farm. And I think that a lot of times, our members, this is daily life. But when we invite the public and guests to experience the agritourism activities, it's not always so obvious that there's mud, there are pests, there are all these animals. And so things can happen.
Exactly. Well, thank you so much, and look forward to doing a couple more of these in 2024.
We will count on it. Thank you so much for your time today, Timothy.
Thank you.
Thank you, everybody. We'll see you in the new year.
Just a reminder to our participants, we are recording it, so I'll make it available to everyone. Oh,
Thank you.
bye.